Now we turn to First Amendment freedom of speech and freedom of association. This is material that you may have spent several months studying in law school. Now, as we get ready for exams, we see that this material really does distill down to a very simple, very short list of issues. And that outline is before you now. You'll see that the issues relating to the First Amendment break down essentially into the regulation of the content of expression, the regulation of the time, place, and manner of expression, the regulation of commercial speech, the regulation of unprotected expression, and then regulations dealing with invasions of privacy. And remember from torts, invasion of privacy is not itself a theory of liability. Invasion of privacy is an umbrella under which a number of different theories of liability attach. And as we saw when we were considering torts, the area of defamatory speech is the area where the law of torts and the law of constitutional law have an overlap. And so we'll be considering that in a little bit of detail here. Now, as we go into a consideration of the regulation of the content of speech, we acknowledge up front that freedom of speech is a fundamental right. So the regulation of content must be supported by a compelling state interest. That's the general rule. And here again, since we're dealing with a fundamental right, we've got to be prepared to apply the correct standard of review. As we consider regulations of the content of speech, one of the things that we have to figure out up front is defining what speech is. And we know that speech goes beyond merely expressing words. Symbolic speech also is protected, and it's also considered speech. There are lots of interesting cases on the point, but for our purposes, it's really quite straightforward. So once we define what speech is, we've got to define what regulation is. Where does a regulation cross the line between being content neutral and being content specific? Again, academically, this is really quite a subtle issue, but on exams you'll see it's much more straightforward than that. We see that protected speech still is subject to a degree of content regulation where there is a compelling state interest or where there is a clear and present danger of lawlessness. So, it is certainly true that a speaker can stand up in front of an audience and argue that the audience should not obey the law. That's protected speech. But where the speaker presents a clear and present danger of immediate lawlessness, particularly violent lawlessness, there the state has a compelling interest in preventing the danger to the public. So if we've got a charismatic speaker standing up in front of an audience arguing, ladies and gentlemen, you should refuse to pay taxes, even if the audience is likely to be persuaded, that's not a speech that the authorities really have the authority to shut down. Whereas, on the other hand, suppose we've got a charismatic speaker in front of a responsive audience saying, the war machine is bad for society, let's go burn down the local army office, and the audience seems likely to follow that lead. Here, the authorities do have the power to shut down that speech based on the content of the speech as a result of the clear and present danger to public order that the speech itself presents. Also, we have got the right to regulate protected speech with regard to the administration of justice and with regard to elections. So, we don't allow people to stand up and make speeches in the middle of judicial proceedings. So, if some guy in the audience is watching a jury trial, he does not get to stand up and express his opinion in open court. He's subject to being found in contempt and cuffed and stuffed into the local jail cell until the proceedings are finished. Similarly, we're all familiar with the fact that it is not legal to engage in politics within a certain boundary around a polling place on election day. There are boundaries around protected speech, and administering justice and administering honest elections are a couple of those justifications. So now we turn to time, place, and manner restrictions, and we see that whether or not the forum is a public, semi-public, or private forum has a lot to do with the extent to which the state can get into regulating time, place, and manner. We also know that the public has an interest and individuals have an interest in privacy and tranquility. So if a lot of people plan to make speeches in the middle of the night using amplified equipment in a bedroom community, it's likely that they can be forced to make their presentation at a more appropriate time, place, or manner. Also, it is true that municipalities can set up appropriate licensing structures so that speech has to be done within the framework organized by the government. Again, time, place, and manner restrictions are essentially legal. Next, we turn to the regulation of the media. Here again, there are rituals that are followed both in the law and in terms of how it is tested. It is legal to require the media to register before attending an event up to a point. You'll see that it's very difficult to make extremely definitive statements in the abstract. We really need to look at cases, and that's why we're going to focus on the First Amendment in quite a bit of detail when we look at the actual hypotheticals. Once again, I counsel you, practice this material. Practice it as in-depth as you can. Annotate your outline to the extent you learn additional useful nuggets of law. Then we turn to the regulation of commercial speech. Here we see that commercial speech is subject to substantially more regulation than other speech. This is quite an interesting point as well, academically, but on the bar exam, it's very straightforward. And typically, bar examination style hypotheticals deal with regulating the commercial speech of those who are selling alcohol or tobacco, intoxicant merchants, in other words, or dealing with commercial speech that has a sexual or a gender component to it. Once again, we'll see hypotheticals that are more satisfying than an abstract recitation of what the law is. We see that there are certain expressions that are not protected, and the biggest of these is obscenity. And we know that there is a definition of obscenity that involves speech that appeals to the prurient interests of a reasonable person in a particular community, a local rather than a national standard. Obscene speech is patently offensive, and taken as a whole, it lacks serious literary, artistic, political, or scientific value. That's a quick definition of obscenity. Probably the easiest example of obscenity is child pornography. This is deemed to be wholly unprotected speech. It can be prohibited, and possessing that material can be criminalized. We see also that to some extent, fighting words are subject to limitation as opposed to mere offensive words. So if I speak to an adversary and I refer to that person as being fat, stupid, and ugly, well, I don't have very good manners, but typically it's not possible to restrict my ability to express those opinions. Now, on the other hand, suppose that I engage in speech which is speaking to somebody's race, somebody's religion, somebody's gender in a particularly harsh, demeaning, and vulgar fashion. Well, at some point, we see that those words are deemed so likely to cause a breach of the peace that we can limit them. And there have been a number of interesting cases over the last 10 or 20 years dealing with speech codes that are designed to protect minorities of various kinds from racist, sexist, or other demeaning speech. These, again, are more interesting academically than they are on law and bar exams. On exams, it's usually typically quite a bit more straightforward. And then we deal with regulations that restrict speech that is deemed defamatory or that invades privacy. Once again, the most common area tested here is where we've got somebody making defamatory comments about a public figure or about a matter of public concern. That speech is protected, whereas if we are dealing with a private figure, and particularly where there is a matter of private concern, it is much more likely that speech restrictions or punishing speech will be considered constitutionally valid. Now, related to First Amendment speech issues are First Amendment freedom of association issues. And basically, the First Amendment guarantees to us the right to associate freely with others. However, we can regulate or put impositions on public employment or licenses or benefits up to a point based on association issues. Obviously, we are not free to engage in criminal conspiracies. However, we are free to associate with people just like ourselves for cultural purposes. So again, the boundaries between constitutionally valid restrictions on freedom of association and unconstitutional ones typically involve some criminality or threat to the community. One thinks of injunctions against young gang membership or young gang members associating with one another in public. These are constitutionally questionable, but they've been upheld in court. We see, finally, on the outline, that there are certain common problems associated with the First Amendment and particularly speech issues. These are the prior restraint of speech, regulations that are overbroad or vague, and then finally the idea of statutes restricting speech that are void on their face. Many of you may have had parents that say, when you are questioning a rule, you don't get to question the rules, you only get punished if you break them. However, in the First Amendment, it is legal to ignore illegal restrictions on speech. Some of these restrictions are so wrong as to be deemed void on their face. And where a restriction on speech is void on its face, a speaker is free to ignore that rule and face the consequences in court, but with the likelihood of prevailing. So that's the broad scheme of the First Amendment with regard to speech. Let's look at a number of specific examples of how this material is tested. I will offer these ideas to you now. You'll see them underlined again and again as you do practice MBE and practice essay questions on these points. We'll make some of these points again in our work together on the hypotheticals that follow. You're going to get plenty of practice in First Amendment issues if you stick with me, and I encourage you to do additional practice on this material on your own. I guarantee that this work is worth points on any administration of the bar exam. This material is important and it is commonly tested. So, remember that symbolic speech is protected just the same way that spoken expression is, up to a point. We know, for example, with regard to draft cards, the act of burning a draft card is certainly an act of symbolic speech. However, the government does have the right to criminalize that expression, not because the government has the right to judge the speech, but because the draft card is government property, and the government has a right, an interest in protecting its own property from being destroyed. So, one could set fire to a phony draft card, protecting the actual draft card, and escape liability. But symbolic speech does have its limits, and that is an example of one of them. We've seen already that all speech is protected except for these really extreme fighting words, defamation, obscenity, and up to a point, commercial speech. We see that with regard to protected speech, the government has to have a compelling state interest, like, for example, avoiding immediate lawlessness, particularly immediate violence. We see that it is not okay to ban commercial speech entirely, but it is okay to restrict commercial speech to protect consumers and for other legitimate government interests. And I think we all realize that the most extreme restrictions on commercial speech have been focused on the tobacco industry. And it's no surprise that on bar exams you are commonly going to see commercial speech issues relating to advertising for tobacco. It is commonly tested across the country. It's also true that the state, under the First Amendment, is not allowed to require citizens to make an expression. Requiring people to display a message, like, for example, an explicitly political message on a state-issued license plate frame. That's illegal too, for the same reason as prohibiting speech. The state cannot take words out of your mouth, and they can't put words into your mouth. We see also that where we have a controversial speaker, up to a point, the state has an affirmative obligation to protect the speaker. So if we've got a speaker speaking in front of an audience that is hostile. Up to a point, the state has to protect the speaker. But where the speaker and the audience are so angry with each other that it's likely that there will be violence, at that point, the state has got the right to shut down that speech based on the content of the speech because the state has a compelling interest in preventing violence. Also, realize that there are lots of forums that are not public forums, and it's okay to restrict speech, even for the government to restrict speech in those forums. So we see that, for example, military bases and jails are not open to the public. They are environments in which the government is expected to exercise a greater degree of control than in all other contexts. Similarly, it's okay to restrict speech on private property. So suppose I'm operating a private club and I'm a member of political party A, and I don't want anybody from political party B to ever express a political opinion at my events. Is that okay? Yes, so long as my events do not rise to the level of state action. So, if I'm just a private bigot running my own little private club, I can have whatever restrictions I want. However, if I begin to take on a more public character, like, for example, suppose that my meetings begin to be attended by a lot of police officers, and then we end up with what is essentially off-duty police officers having an additional meeting. Well, we can add additional facts to this pattern up to the point where I think we'd all agree that basically we've got state action, even though on its face everybody making decisions is a private party. Well, we know that as soon as state action has been established, constitutional freedoms become much more subject to litigation. It's okay to restrict speech in a private forum, but as soon as it becomes a public forum, there's state action present and the restrictions become illegal. Finally, with regard to communications about sex or nudity that we stipulate to be non-obscene, under those circumstances, the state still does have the right to place reasonable time, place, and manner restrictions on that non-obscene speech. That's why modernly in broadcasting, late at night, broadcasters have got significantly more freedom to have more frank discussions of sex, more frank displays of sexual behavior than earlier in the evening. And that's about all I think you need to know up front about the First Amendment. Maybe you spent the better part of a semester in law school on these issues. And here we've spent somewhere between 15 and 20 minutes. Obviously, this is a very superficial presentation, but I've given you all of the basics that are tested. You will probably feel like fleshing out the outline that I've provided a little bit as you engage in practice, but I think one thing you'll see as you get into your work on this material, it's much more straightforward and easy on the bar exam than it is in law school. So now I encourage you, carefully practice all 6 of the hypotheticals, review them with the videos that come with, and I think by the time you're done, you will be a seasoned veteran, well prepared for just about any constitutional law issue.